The Supreme Court has upheld the appeal filed by the People's Democratic Party challenging the competence of the suit and jurisdiction of the Federal High Court to hear the suit filed by the former governor, Timipre Silva, asking the court to declare him the authentic candidate of People's Democratic Party in the February the 11th governorship poll in Bayelsa State, having emerged as the party's flag bearer in the January 2011 governorship election. The judgment, which was written by Justice Bode Rhodes Vivo and delivered by Justice John Fabiyi, noted that the cancellation of the April 2011 governorship election in Bayelsa State as a result of the suit filed by Mr. Silva, saying his tenure will not end until May 2012, which was upheld by the appellate court, had rendered the January primaries null and void, and as it went with the cancelled polls. The court therefore maintained that it is non-partisan, and since primaries are clearly a party affair, the law court has no jurisdiction in the suit. Justice Rhodes Vivo added that in the circumstance it will be an anomaly for the court to evoke Section 22 and try the suit as if it were the court of first instance, since it lacked jurisdiction. He concluded by saying that the court will continue to remain a passive onlooker on internal affairs of political parties, and thereafter dismissed the ruling of the appellate court and the suit filed by former Governor Timipre Silva, pending before Justice Gabriel Kolawole at the Federal High Court in Abuja. The People's Democratic Party had filed an appeal at the Supreme Court challenging the ruling of the appellate court, which gave jurisdiction to the Federal High Court to try the matter.
The appeal by Governor Dixon at the PDP succeeded, and the court has said that the courts don't have jurisdiction to deal with the subject matter of the case. It's a policy decision. The courts have for a long time tried to stay away from partisan politics. They try not to be dragged into it. And the National Assembly in the 2010 Electoral Act provided that those aggrieved by the process by which primaries were conducted could come to court. The whole idea was to install internal democracy in the political parties, because so much that had gone wrong with the country had to do with inter-party disputes. The Supreme Court, in its wisdom, feels that the court should still be insulated from that process, and we have no choice. We accept the decision of the Supreme Court.
That was a very sound pronouncement of the Supreme Court, because they have earlier pronounced in several judgments that pre-election matters are not supposed to be taken to court. And that was exactly what they pronounced. And we are very happy about it, because when we lost at the Court of Appeal, we made bold to appeal to the Supreme Court based on a dissenting judgment of Justice Balajuka. And what that dissenting judgment has come to be was what the Supreme Court pronounced. And that is why we always say that in litigations, the Supreme Court is the final court.